Several laws affect marketing. One way to understand the various laws is to divide them into two broad categories: consumer protection laws and pro-competitive laws. In this video, I introduce two examples of pro-competitive legislation. In general terms, pro-competitive laws are designed to protect vigorous competition among companies. These laws recognize the fact that the general public benefits when companies must compete with one another to win consumers' business. This competition drives innovation, the development of better products, and lower prices. Many laws were passed to end anti-competitive activity, such as stealing trade secrets, unfairly using another company's brand name, secretly fixing prices so consumers would have to pay higher prices, false and deceptive advertising, paying bribes, and market division, which means that competitors divide up customers so they won't have to compete with one another. For example, two competitors might decide that one company will get the U.S. market while the other will get the European market. The first pro-competitive law that I will cover is the Sherman Antitrust Act, which was passed in 1890. This is a powerful law that gives courts the right to impose large criminal fines and penalties of hundreds of millions of dollars. In extreme cases, the courts can actually break a large company up into several smaller companies. This law was not originally intended to have an impact on companies that grew large because of honest innovation and honest efforts, but you can be sure that very large companies attract the attention of antitrust regulators. There are two kinds of violations with the Sherman Act. One type is called a per se violation. A per se violation is so clearly anti-competitive that it's an automatic violation. The actual impact and the motive don't matter. Here are three examples of per se violations. First, price fixing. This is when two or more competitors mutually agree to coordinate their prices, so they're not actually competing based on price. 2. Bid rigging. This is a fraudulent scheme in procurement auctions resulting in non-competitive bids. And 3. Market division. The second kind of violation is called a rule of reason violation. With these violations, trade practices are illegal only if they place an unreasonable restraint on trade. This looks at all the circumstances and assesses the impact of the practice. Intent and motive are important. This requires the court to assess the impact of a practice on competition. Actually, the Sherman Act does not even define the term competition or give any test for measuring whether it has been restrained. The rule of reason is used when deciding whether mergers between large firms are legal. It's used when deciding if a firm has formed an illegal monopoly, and it's also used in cases dealing with predatory pricing. The second pro-competitive act I will discuss is the Foreign Corrupt Practices Act, commonly called the FCPA. This law was passed in 1977 in response to its disclosures of illegal payments to a variety of foreign government officials. At the time, paying bribes to foreign officials were not directly prohibited by U.S. law. This law clearly made payments of these bribes illegal. The law also contains what is called a books and records provision, which requires businesses to maintain accurate books, accounts, and records which honestly and accurately detail the transactions involving the business's funds. This law prohibits paying anything of value to a foreign official to obtain or retain business. But what does foreign official mean? Around the world, many companies are at least partially owned by a government. For example, Airbus is partially owned by the French government, the Spanish government, and the city of Hamburg. According to the FCPA, any Airbus employee purchasing something for Airbus is considered to be a foreign government official. A safe interpretation is to treat all employees of all organizations that are at least partially government-owned as foreign officials. What does anything of value mean? Well, it can include dozens of things in addition to cash payments. Business-related travel and entertainment is not a problem unless it's excessive. A firm could easily justify buying dinner for a potential customer, but paying for private jet travel would probably be considered excessive. If the travel was accounted for as a legitimate marketing expense, that would also be a books and records violation. Employing a buyer's child or promising employment would raise questions. This provision is very broad and there's no minimum value. It does exclude so-called facilitating payments, which are small payments to speed up routine government actions such as processing papers. There are some affirmative defenses. An affirmative defense is when someone affirms the charges but raises other facts that would defeat the claimed violation. If excessive entertainment is lawful under the written laws and regulations of the official's country, that could be used as an affirmative defense. A bona fide expense such as reasonable travel and lodging could also be used with an affirmative defense. The term third party is any entity other than the selling organization and the buying organization. To facilitate the delivery of goods to markets across the world, companies rely on an array of agents, consultants, distributors, and other third parties operating in foreign markets. The third parties provide local expertise, experience, connections, and satisfaction of some local requirements that foreign companies collaborate with local entities. However, a significant percentage of anti-bribery violations are based on the conduct of third parties. Here's some red flags associated with third parties. Excessive commissions to third-party agents or consultants. Third-party consulting agreements that only include vaguely described services. Or unreasonably large discounts to third-party distributors. That's a look at some of the federal legislation as part of the marketing environment. Thanks for watching.